At the close of oral argument in late April 2025, a most extraordinary scene unfolded within the Supreme Court's hallowed chamber. All 9 justices rose to applaud Edwin Canadler, a career advocate in the Solicitor General's office. As he concluded what would prove to be his final appearance before the bench, Canadler, who had devoted 46 years to representing the United States in the court, was marking his 160th and record-setting oral argument on behalf of the federal government. The ovation, led by Chief Justice John Roberts, was the first of its kind in the court's entire history. Here, far from a mere tribute to longevity, the gesture communicated a pointed rebuke to President Donald Trump's ongoing assaults on the judiciary and underscored the institution's collective commitment to the rule of law. Behind this symbolic moment lies a sweeping turnover within the Department of Justice that has accelerated under the combined leadership of President Trump and former Florida Attorney General Pam Bondi. Over the past 2 years, more than half of the DOJ's seasoned prosecutors and civil service attorneys have either accepted reassignment deals that include incentives to resign or have departed outright. Remaining staff report substantial increases in workload paired with diminished resources and fractured morale. The departures have produced alarming collateral effects. Toddlers under the age of 5, some of whom are United States citizens, have been erroneously deported to foreign countries. Confidential attorney-client and department memos intended solely for internal review have mistakenly been filed in open court, and in over 150 lawsuits challenging administration policies, plaintiffs have achieved prevailing verdicts at every judicial level, including more than 100 injunctions against federal action. The Civil Rights Division, long regarded as the jewel in the DOJ's crown, has suffered a particularly acute crisis. Under Harriet Dillon's tenure as division chief, an appointee closely aligned with the Trump-Bondi agenda, approximately 70% of the division's lawyers have signaled their intent to exit. Many of those who remain have been reassigned from investigating police brutality, voting, rights violations, and gender discrimination to implementing policies widely criticized as antithetical to core constitutional guarantees. The division's foundational mission to protect American civil rights has thus been supplanted by initiatives that adversaries argue erode, rather than enforce, equal protection standards. Amid this institutional unraveling stands the Solicitor General's office, itself an elite corps of just 16 attorneys responsible for handling every Supreme Court appeal on behalf of the United States. Commonly labelled the 10th Justice, the Solicitor General manages a docket that can encompass upwards of 40 cases in a single term, though only a fraction, typically 20 to 30 arguments, are personally argued before the bench. The office's head, ranking 4th in the DOJ hierarchy, is charged with safeguarding the government's credibility in the nation's highest tribunal. It was against this backdrop that Edwin Canadler, widely acknowledged as the office's guiding light and mentor to successive cohorts of appellate lawyers, announced his surprise retirement. His decision to step down immediately following his milestone argument, one that featured impassioned defense of constitutional separation of powers, has been attributed by colleagues to mounting discomfort with defending policies they regard as legally unfounded and ethically dubious. Canadler's departure, along with 8 other veteran advocates, will reduce the office's roster to fewer than 8 experienced counsel at a moment when appellate challenges to executive actions are surging. The Supreme Court's standing ovation for Canadler transcended mere recognition of personal achievement. It served as a collective, if unspoken, statement of judicial independence and disapproval of executive branch tactics perceived as undermining the courts. This silent theatrics followed a rare, overt rebuke in March 2025 when Chief Justice Roberts issued a public declaration admonishing President Trump for advocating the impeachment of sitting federal judges. Roberts reminded the executive branch that calls for judicial removal, past occurrences in United States history having numbered no more than 15, distract from the proper channel of appeal and threaten the judiciary's institutional integrity. By orchestrating a mass standing ovation, the justices reaffirmed their allegiance to reasoned adjudication and transparent advocacy, qualities epitomized by Canadler's tenure. and signalled frustration with recurrent executive overreach. They applauded not only the departing advocate's unwavering candour, professionalism and scrupulous honesty, but also the broader principle of an independent judiciary acting as a check on unchecked power. In an era when the presidency has repeatedly assailed federal judges as a lawless, a leftist activist, or a Marxists, the Supreme Court has begun to deploy both symbolic and substantive measures to maintain equilibrium among the branches of government. Beyond Roberts' public statement, the institution has quietly expanded the scope of oral argument, tightened deadlines for government filings, and signalled heightened scrutiny of executive branch litigation tactics designed to delay or deflect judicial review. The emergence of specialised legal news platforms such as the newly launched Legal AA channel on YouTube, helmed by journalist Michael Popak in collaboration with the Midas Touch Network, reflects a growing public appetite for in-depth coverage of these constitutional confrontations. By curating stories at the intersection of law and politics, such outlets aim to illuminate the stakes of high-profile cases that will shape the contours of American governance for years to come. As the Solicitor General's office prepares to rebuild its depleted ranks, and as the Supreme Court continues to navigate its role under intensified political pressure, the standing ovation for Edwin Canadler will stand as a vivid reminder the courts retain their ultimate power in persuasion. Not coercion, an influence measured not in executive fiat but in the reasoned judgments and collective resolve of 9 independent jurists. In the wake of Canadler's departure, attention now turns to the office of the Solicitor General's capacity to sustain the rigorous standards he embodied. Recruitment efforts are already underway, but the challenge will be to attract and retain advocates of comparable experience and integrity at a moment when the broader Department of Justice is perceived as politically compromised. Prospective applicants may weigh the prestige of arguing before the Supreme Court against the diminishing institutional autonomy, now on display. How the administration structures incentives, they policy-driven assignments, career advancement opportunities, or assurances of non-partisanship will profoundly influence whether the office can rebound or continue its attrition. Beyond personnel concerns, the court's recent actions illustrate a broader strategic recalibration. By openly lauding an advocate's fidelity to fact-based argumentation, the justices implicitly critique the rising frequency of government briefs that prioritize political expediency over coherent legal reasoning. Observers note that in the current term, the court has declined to grant certiorari in several high-profile cases, perhaps reflecting reluctance to become entangled in contests, where the government's positions appear increasingly untethered from precedent. This cautious docket management, coupled with symbolic gestures like the standing ovation, signals a judiciary keen to preserve its legitimacy amidst mounting external pressure. The implications extend to executive policymaking. Agencies, aware that their litigation posture may be scrutinised both in open court and in public perception, might recalibrate how they frame regulatory and enforcement initiatives. A more harmonised approach, one that solicits input from career attorneys and upholds established legal frameworks, could mitigate the adversarial posture that has characterised many recent government appeals. Should the Solicitor General's office reconstitute itself around these principles, it would not only restore internal morale, but also reinforce the executive branch's credibility before the judiciary. Longer term, the episode raises questions about the balance of power among the branches. If the court continues to leverage procedural norms and public pronouncements to check executive overreach, it may embolden Congress to assert its own oversight role more vigorously. Legislative hearings examining DOJ staffing decisions, funding allocations, or the criteria for appointing appellate advocates could emerge as focal points in the next congressional session. Such oversight would represent a parliamentary complement to the court's judicial independence, ensuring that no single branch can monopolise constitutional interpretation or enforcement. Ultimately, the standing ovation for Edwin Canadler crystallises a moment of institutional self-assertion. It underscores the judiciary's reliance on principled, experienced counsel to uphold the rule of law and it demonstrates the lengths to which the court will go to protect its own integrity. Whether this episode ushers in a renewed era of respect for non-partisan legal advocacy within the Department of Justice, or whether it remains an isolated repudiation of the current administration's tactics, will depend on the choices made now by both policymakers and practitioners. For observers of American governance, the message is clear. Even in times of intense politicization, the architecture of checks and balances retains the capacity to resist encroachments on judicial independence, so long as its guardians heed the call.